I call the case, I want to thank the parties for accommodating our schedule change. Call now cause number PD-0251-22, Callie Renee Inman versus the State of Texas.
Good morning, and may it please the court. My name is Joshua Kelly, and together with my colleague Jeth Jones, I represent Appellant Callie Inman. The central issue before the court is a matter of first impression. Does the Confrontation Clause of the Sixth Amendment apply in community supervision revocation proceedings? We're asking the court to hold that it does apply in revocation proceedings, given their unusually judicial and adversarial nature. In doing so, we ask that the court reverse the Court of Appeals' decision and remand the case for a new hearing on the state's motion to adjudicate. In this case, the 13th Court of Appeals refused to conduct a Confrontation Clause analysis, holding that the Confrontation Clause does not apply in revocation proceedings. This holding, however, deviates from a prior 13th Court of Appeals decision from 2015, Perez v. State, in which the court stated that, quote, if the rules of evidence and exclusionary rule apply to community supervision proceedings, so should the United States Constitution.
Counsel, the Confrontation Clause applies to prosecutions. With a deferred adjudication, the defendant has already pled guilty, has been given a chance to prove that they can comply with the terms of their probation, and when they can't, there's a revocation proceeding. It's done by a preponderance of the evidence. So how is that a prosecution?
That's why in our briefing we focus on this court's decision in Ex parte Doan. In that case, this court's noted that as opposed to the federal revocation proceeding, Texas proceedings are adversarial in nature. And I think the key difference there is that the rules of evidence apply. And the Confrontation Clause was designed, I believe, to complement the rules of evidence because it addresses that specific instance in which evidence might be accepted from the hearsay rules.
Or the other way around.
What's that?
Or the other way around. I think the Confrontation Clause is a little bit bigger than the rules of evidence.
Exactly. I think it provides extra constitutional rights to situations in which a court is going to hear evidence to which the rules of evidence apply. And it specifically addresses the situation in which something might be accepted from the rules of evidence that would still confront or still violate someone's right to confront testimonial evidence. And so I think, to answer your question more directly, it's akin to a criminal prosecution, as this court's noted, because a judge is going to hear evidence and based on that evidence decide true or not true on alleged violations of community supervision, and then decide in deferred adjudication whether to adjudicate guilt in the first place and then use that to actually sentence the defendant.
But the terms and conditions of probation are separate from the underlying offense. So the defendant's not being prosecuted for the underlying offense. The defendant is being adjudicated based upon whether or not they can comply with terms of conditions of probation.
That's true, but I would strongly urge the court to consider the fact that, again, in order for the state to even go forward in a confrontation clause or in a revocation proceeding, you still have to make that finding of true or not true on the alleged violations, and that is based on evidence presented live in the court. But
it's by a preponderance of the evidence.
It is by the preponderance of the evidence, but it's still based on live evidentiary testimony, and I think that's important because, again, the Confrontation Clause goes hand in hand with the rules of evidence. The court in Crawford, the United States Supreme Court in Crawford stated that to leave out-of-court statements to the law of evidence would render the Confrontation Clause powerless. And I think that's important here because it might be by the preponderance of the evidence, but it's still based on testimony being provided before a judge. And again, the 13th Court of Appeals here didn't consider this. It largely relied on precedent predating this court's decision in Ex parte Doan. And after this court decided Ex parte Doan, there was a lot of uncertainty in the state. For example, after Ex parte Doan, several courts assumed that the logical extension of that would be the Confrontation Clause applies in revocation proceedings. And these cases come from the First Court of Appeals, 8th Court of Appeals, 14th, and even the 13th Court of Appeals. And so this court now has the opportunity to explain the effect of that rationale applied in Ex parte Doan, which is important because, again, in Ex parte Doan, this court contrasted the nature of Texas revocation proceedings from federal revocation hearings.
Well, what is the difference? What are the differences? Like, what protections are greater here than there are in federal probation, community supervision?
The court in Ex parte Doan focused on the fact that it's before a judge, a prosecutor's involved, and I think most importantly here that the rules of evidence don't apply in federal proceedings. That's actually stated in the federal rules of evidence, 1101, that the rules of evidence are accepted from proceedings on revocation, community supervision revocation.
But if they can remove those things in federal court, doesn't that cut against the idea that the Constitution would apply in those situations?
Well, I don't believe so because, again, Ex parte Doan recognized that in federal court, that is a purely administrative hearing. There's a prior hearing in federal court to determine probable cause in the violation, and then there's a sentencing hearing. In Texas, this is all one judicial process. A court's going to hear evidence, and under the due process clause, you have the right to confront those witnesses who are brought forth, but under the due process clause, which this court has held does apply in revocation proceedings, you don't have the right to exclude testimonial hearsay. And that's why I think if the rules of evidence are going to apply, Texas has made that decision, that the confrontation clause has to also apply, because they go hand in hand.
But counsel, and with probation or deferred adjudication, the judge who's under whose supervision the defendant is has the right to modify the terms and conditions of probation without a true hearing, without any other proceedings, just an administrative hearing or complaints by the probation officer that they're not doing what they're supposed to do, and the judge can then modify terms and conditions, add terms and conditions of probation. So that to me, does seem more administrative, while the revocation proceeding is adversarial. I agree. It's not really a prosecution, though.
I think in terms of in a deferred adjudication, it would be, because there's no conviction on the front end in a deferred adjudication. The judge still has to decide based on evidence whether to adjudicate guilt before sentencing. And in this situation, a judge did do that based on over objections to evidence that were testimonial hearsay.
He's not relying on evidence obtained in violation of the Confrontation Clause in order to find the defendant guilty. So they're not really applying the Confrontation Clause to the guilt or the finding of guilt. They're applying it to whatever the sentence is going to be, maybe, or the decision to sort of revoke.
Well, it's not just the decision to revoke, it's also the decision to adjudicate guilt in deferred adjudication.
But the defendant has already pled guilty to
Right.
the offense.
They have, and in doing so, they've waived the right to a jury trial under Sixth Amendment, but they haven't waived the right to the Confrontation Clause. And I think that's important here, because when you do an admonishment in your plea deal, you do give up your right to a jury trial explicitly, and that's even included in Article 42A.751. Statutorily, you don't have a right to a jury trial in a revocation proceeding. But you do have the rights to the rules of evidence. And again, where the rules of evidence go, so should the Confrontation Clause, because it specifically addresses that moment in which something might be accepted, like a business record, from the hearsay rules, but it would still violate one's constitutional rights to confront people testifying against them.
Even if the evidence was sufficient to support, for example, one of these grounds that the revocation motion was based upon, the trial court would still at that point have discretion whether or not to adjudicate guilt. Isn't that correct? In a very real way, it does impact what he sees in the evidence relating to the motion to adjudicate has some impact on whether he exercises his discretion to find guilt or to continue the deferred process, right?
And or even put them on straight probation after that hearing.
So you would agree, I think, let me answer this one question for me. It only takes one finding of a violation to support a revocation and an adjudication, right?
Yes, Your Honor.
And the state argues in its brief that at least some of the evidentiary support for the adjudication was not sufficiently preserved at trial. Do you have any response to that?
I do. The state focuses on specific testimony that go to one or two of the allegations, but I think it's indisputable that, for example, allegation 10A, which is that Ms. Inman admitted in writing to consuming marijuana. That writing wasn't offered as evidence. Ms. Inman didn't testify to that. The state offered a probation officer who wasn't supervising Ms. Inman at the time that admission was allegedly made. Instead, she read from a report from someone who wasn't at trial and wasn't able to be confronted by Ms. Inman.
But I'm really asking about, like, what did trial counsel do to object to that? Was his objection, did it not come until later, or was it timely when the evidence was offered?
The state admits in its brief that we timely preserved error on that specific testimony, and that is the only basis for the finding of true of allegation 10A. And if one allegation is undercut because it was based on testimony or hearsay admitted over objection under the Confrontation Clause, then it's the state's burden to prove beyond a reasonable doubt that that did not contribute to Ms. Inman's punishment or sentencing. And I think the state can't meet that because while one violation might support revocation, the quality and quantity of every allegation will factor into a court's determination of whether or not to adjudicate guilt in a deferred adjudication and the sentencing that he imposes on the defendant. And again, that's the state's burden beyond a reasonable doubt to prove that. And so while the state points out a few instances in testimony, I'd argue that some of that testimony he points out in his briefing doesn't actually address any of the allegations eventually found true.
The burden of beyond a reasonable doubt, you mean the harm standard? Like if there's error with regard to one allegation because there's some Confrontation Clause violation for one allegation that leads to the revocation, then you're saying that the entire process is tainted because the state can't prove beyond a reasonable doubt that that one allegation didn't contribute.
Yes, Your Honor, because
Then why can't you just why is it the other way, which is there's plenty of evidence to suggest that they could have been revoked on any of these other things, regardless of this violation?
well, again, it's a difference between straight probation and deferred adjudication. You're not just revoking someone's community supervision. You're also deciding whether to adjudicate guilt upon that evidence and then determining the sentence at that hearing as opposed to relying on a prior sentencing that would happen in a straight probation.
So, let me ask, then that actually raises another question too, though. So, you're fashioning a rule where we would say the Confrontation Clause applies to deferred adjudication, but doesn't necessarily apply to probation itself?
I don't think there should be a line drawn. I think ultimately, the Confrontation Clause should apply when the Texas Rules of Evidence apply, especially in a revocation proceeding, because prison time is on the line. That is a liberty interest that applies to both of those. There might be a stronger liberty interest in a deferred adjudication because there is no actual adjudication until after the revocation hearing. But I would ask the court not to draw that line, but I would obviously defer to the court on that issue.
Well, it's not in front of us. It's just sort of the concerns is the consequences of what we would rule in this case might affect how we would view a probation case.
It would. I think in our briefing we've asked to make the broader ruling, but you're right, Ms. Inman was on deferred adjudication, so it would be limited to deferred adjudication should the court choose that.
I guess following on from what Judge Newell said, I mean, we've all either been in court or heard stories of judges that will adjudicate you and send you to the max for failing to report one time. So how are we supposed to determine, I mean, if your client was in front of a judge like that, well, then they're going, I mean, there could be 10 allegations. You could disprove 9 of them, and the only one that's proven is that they didn't report, and the judge goes, well, that's the one I believe. We're going with that. Like, how are we ever going to get to the bottom of whether or not, the harm question here?
Again, that's the state's burden. I would stress that each one of these allegations, both the quantity and the quality of any of the allegations found true, would have to contribute, at least in the sentencing, because they're sentencing guidelines.
Has this court said already that it is the state's burden to show harm
It has, yes.
or to disprove harm?
Yes, Your Honor. Let's see. It has, yes, Your Honor. I don't have the case name in front of me, but this court has stated that it's the state's burden. So unlike the Due Process Clause, because the Due Process Clause bakes in a harmful error analysis whether or not the Due Process Clause was violated, the Confrontation Clause is a procedural defect. You either violate the Confrontation Clause by admitting testimony and hearsay or you don't. And then once that's found, then there's a harmful error analysis. And at that point, it is the state's burden to prove beyond a reasonable doubt that harmful error was not caused by the omission of that testimonial hearsay. And I think that's a key distinction between the due process right to confront and the Confrontation Clause right to confront. That there can be a procedural defect found before even touching the harmful error analysis.
I mean,
So, I'm sorry. So, am I correct to assume that you don't think defendants that are put on deferred have gotten some kind of benefit. So we should just, I mean, they've already received a benefit by being placed on deferred. Okay, so they should have all the same rights as everybody else, even though they received a benefit. It should just go on and on.
I'm about to go over time, but can I would say yes. The state Texas has already decided to allow a hearing to go forth that is adversarial in nature and apply the rules of evidence. That applies across the board. While yes, deferred adjudication is one of the best deals you can get, absent an intervention, that doesn't mean you can give a right and take away all the accompanying rights. I think, Judge Yuri, you made the analogy, you can't give someone the right to an appeal but not give them the right to effective counsel on appeal. I think in this situation, you give a right to a hearing in which the rules of evidence apply, and the 13th Court of Appeals has stated that even though we give that right, we don't also give the right to the Confrontation Clause, which again is designed to address the specific instance in which something might be accepted from the rules of evidence, but still violate someone's constitutional right to confront the person giving that testimony.
Well, I wanted to ask you, I know you're out of time, so I want to ask you a question that was sort of a broader gauge question, so I'm really sorry to ask you to explain everything all over again, but I'm not going to do that. But the federal sentencing is different. So is there really the same kind of structure where we have a right to, like in Texas, we have a right to a punishment trial, right? And sentencing is not nearly as elaborate in federal court. Why is it that we would think that the Confrontation Clause would have been enacted or would apply in these circumstances when even in the federal system it doesn't seem like that is at all what they're thinking of how criminal systems should work? Why isn't it more along the lines of we shouldn't be looking to see if the Texas Constitution has a provision for the confrontation, a right of confrontation that might apply because it's more built towards the Texas way of doing things?
I think the simplest answer would be that the 14th Amendment gives the states the rights to claim rights from the constitutional rights,
Right.
and that would include the 6th Amendment.
Right.
And I understand that Texas has created a novel procedure. This court's recognized that in Ex parte Don't. But in doing so, they have granted rights to things like counsel, the right to the rules of evidence. And where the rules of evidence go, I think the federal court would even recognize the Confrontation Clause should also go. Because again, the United States Supreme Court said to leave out-of-court statements to the rules of evidence would render the Confrontation Clause meaningless. And I think that is important because, again, Texas has chosen to give the rights to defendants to a hearing in which the rules of evidence apply, and the Confrontation Clause should also apply.
Thank you.
Thank you, counsel.
Thank you.
Mr. Curry, before you begin, is the timer sitting in front
It
of you?
says 20?
The
Can you-
lights,
We can't see the light.
Would you put it up on top?
Oh,
of the-
sure.
Thank you.
If it
you
will
can.
go up there.
Well, I didn't notice either. Okay, thank you.
All good?
Yes, you may proceed.
Order,
Ready, set, go.
May it please the court, my name is Alan Curry. I'm with the Galveston County Criminal District Attorney's Office, and I represent the state of Texas in this case. Because a hearing on a motion to revoke community supervision and/or a motion to adjudicate guilt is not a criminal prosecution, the defendant's Sixth Amendment right against having testimonial hearsay, the Confrontation Clause, does not apply. That doesn't mean that the hearing is not criminal. That doesn't mean that the hearing is not judicial. It just means the Sixth Amendment doesn't apply. The rules of evidence apply. There is a confrontation right that does apply, but the Sixth Amendment Confrontation Clause doesn't apply. That's all we're asking this court to hold. That's all the Court of Appeals hold, and I think that's the primary issue.
Well, explain that to me. There's a confrontation right that applies, but it's not the Sixth Amendment confrontation. So where do we get the right to confront?
The due process clause, Your Honor. And that would be from Gagnon versus Scarpelli, Morrissey versus Brewer. This court has not had the occasion, and probably doesn't have the occasion in this case, unless you want to just pontificate, about what that would look like.
If I'm bored on a Saturday, I mean,
So, I mean, I've given you know, the last part of my brief, which I don't expect the court to say anything about, but I've given some indication what other courts in other states have done. I stayed away from federal case law because, you know, this court has already seen that in another case, and also because I agree the federal procedure, as this court said in Ex parte Don, is quite different from ours, and frankly, a lot of other states as well. But, so there is a right of confrontation, just not the Sixth Amendment right, and that's the objection that was made. Judge Erie, you asked about objections that were made. I'm not standing up here saying a lot of stuff got into evidence over a confrontation clause objection. You know, that issue is definitely before you. Some evidence did not come in over a confrontation clause objection. There were hearsay objections made. One allegation, no objection was made to it. That probably would, you know, go into a harm analysis if I lose everything today.
Would you agree that the state has the burden to disprove harm beyond a reasonable doubt?
I don't think that the case law says that there is a burden. I think the case law would place the burden upon the appellate court to conduct that analysis. If we agree or believe that 44.2A comes from Chapman, then I think that's where we would start looking at that. You know, there may be a case that talks about burden. I didn't brief harm because I didn't know that I don't think we're going to get there. I would imagine it would be remanded. But if not, I'd be glad to brief harm and answer that question. But I don't think that question is necessarily before this court.
Do you have a response to the idea that, well, if some of the evidence shouldn't have come in, even though other valid evidence might have proved a violation, that evidence that came in that shouldn't, that we should consider that somehow as potentially harmful?
Well, I suppose it's potentially harmful, but you still have to square with the idea that in a motion to revoke and in a motion to adjudicate, one allegation is enough. And some judges will do that. One allegation is enough. But, and I think that has to play a role in whatever harm analysis a court would conduct. Even if it's a constitutional harm analysis, you would still have to look at the idea that in this proceeding, one allegation is enough. Just like in a criminal trial, if the evidence is overwhelming, that is definitely a factor that the court would take into account.
Did the trial court memorialize in any particular fashion, either on the judgment or in findings of some sort, the fact that it found in favor of one of those violations that you contend was not preserved?
Well,
Are you following me? In other words,
I guess
did the
not.
trial court say, with regard to those allegations that you contend the argument is not preserved for these, did the trial court say in its judgment, I find that to be true?
well, the judge made findings of true and not true.
Okay.
But, you know, and then you would just have to look at those that,
Well, that's what I'm asking.
Yeah.
Is that memorialized somewhere in the record that we can go to and confirm?
yes, I've cited it in the record, Your Honor.
Okay.
If I'm understanding your question, I'm not sure that I am, but
Did the trial court find true an allegation that had no confrontation clause problem in
yes,
it? Okay.
Was it allegation number 7?
yes.
Yes.
That's, maybe that's your question. Allegation number 7 was not touched at all with regard to any kind of
Confrontation clause.
objection that we're talking about here.
Let me just ask, normally when you have a motion to enter adjudication of guilt, that procedure takes place first, whether or not the trial court is going to find the defendant guilty. And then after that is done, then they move to what the sentencing should be.
Yes.
So they're kind of like two separate hearings, in essence. You split it up. Do we agree on that?
Well, there's case law to that effect, Your Honor. It's evolved a little bit to where if the defendant is provided the opportunity to make that, presentation of any mitigating evidence
Right.
he or she wants to,
And-
then.
And
but
somewhere in the back of my mind, in the thousands of pleas I've taken, I remember, I don't have the code in front of me, the defendant is admonished that if I grant your application for deferred adjudication and the state subsequently files a motion to find you guilty, you can't appeal from that finding.
Your Honor, they keep changing what you can and
Is that
cannot
still in
appeal from.
existence? Because I'm
It
curious
is,
if
but it's a limited.
if it's
Yeah.
in
The
day
existence,
is we.
then why are we even here on the adjudication portion of it?
Yes, Your Honor, the defendant can appeal from that. The law has since changed.
Okay.
I suspect. Don't get me started talking about it, because I've changed it so often.
But
I've been doing this for a long time too, so.
Isn't it that the, on the adjudication, you should have 30 days from the date of the plea or what have you, but then they can't really go behind it?
I believe so, yes,
Okay.
Ron, but, you know.
I don't want to pontificate.
I didn't brief the,
So is it your position that the evidence introduced at the adjudication phase just carries over to the sentencing phase?
well, sure. I mean, everything would carry forward, looks like
You
any
don't
other
have to reintroduce
sentencing.
it or anything like that? You just,
Right.
it's all, okay.
I mean, the statute says that the sole issue to be looked at by the jury is whether or not the trial court should proceed with adjudication.
Right.
And reading the statutes in context, that means that you're trying to decide whether or not the defendant violated the conditions of her community supervision or not.
But then he has the opportunity to argue to be placed on probation after a sentence is imposed, correct?
Sure.
Okay.
I mean, that's a possibility. I mean, but, you know, after that happens, then you start talking about everything else that would have occurred if guilt had not been deferred.
Okay.
Sentencing, appeal, whatever else.
Right.
This court had decided a case last year in Middleton in which Judge Keller wrote that it's kind of a pause. You've got the plea of guilty.
Right.
Then you have this pause where the defendant starts serving probation and there's an adjudication hearing. After that adjudication decision has been made by the judge in the state's favor, then sentencing would occur and appeal or whatever else. And in that respect, you know, my contention would be that there really is, for Sixth Amendment confrontation, at least with regard to the questions before this court, there really is no distinction between a deferred adjudication proceeding and a motion to revoke proceeding. The hearings are the same. The probations are very different. The impact on the defendant's future is very different, but the hearing is the same. There's no real difference.
You know-
So,
Sorry.
Go ahead.
I was just thinking about how, I've seen a lot of pleas, you know, and there's usually this point in the process where the trial court judge will say something like, is there any reason why I should not pronounce sentence at this time, right? And that's, I almost never see anybody say that there is a reason, but that's kind of a pause also. And it also takes place in the context between when the evidence is presented and guilt is determined and when the sentence is imposed. And I wonder, is there a confrontation right that exists at that point during that sort of pause when the trial court is ascertaining?
that is a good question, Your
Yeah.
Honor. The question that this court certainly hasn't answered. This court has, you know, stated in dicta, wondering whether how far or does the confrontation clause apply to actual sentencing. I don't think that the question is before you in this case. I think we're dealing solely with whether or not the confrontation clause to that part of a hearing in which the state is required to prove violations of conditions of probation or community supervision. I mean, that somewhat close to Judge Richards' question about there needing to be two things happening, the adjudication and then sentencing. This court has decisions about that and whether it has to be separate and how it has to look. I haven't briefed that. I remember it because I've been doing this for a while. But, so I am not asking this court to issue a holding that the confrontation clause does not apply to sentencing.
Okay.
I want to dovetail back to a question I asked earlier, though, about the difference between the due process confrontation and the Sixth Amendment confrontation. I just wanted clarification. Is your argument then that there's this other confrontation right under the due process that we would have to consider whether this falls under that? Or is the argument that because they only objected under the Sixth Amendment, we don't even get to the due process confrontation?
The latter.
Okay.
I don't think you would get to due process, but I have added a couple of pages at the end of my brief as to what that might look like.
Well, what might it look like?
It might look like, is what otherwise would be considered testimonial hearsay, if it is testimonial hearsay, is it reliable? Is it something that, you know, probationers and judges dealing with probationers rely upon on a regular basis? This was a business record. Well, I've had no complaint that it wasn't a business record, that it was conducted during the regular course of activities. And if it is a business record, then it wouldn't be testimonial. But there could be some hearsay.
Sure.
So if a witness comes into court, sits down and starts testifying, the state passes the witness, the defendant gets to cross-examine that witness.
Right.
Obviously. At least I hope. I mean, I'm definitely not arguing that. You know, and if the defendant would be able to challenge the legitimacy of any kind of record that we presented, anything else. This defendant testified. So, you know, she was able to confront some of the allegations and disagreed with our interpretation and stuff like that. So, but that's how I believe it would look like. You would look at the hearsay and try to determine if it was reliable. What happened to the defendant, for lack of a better way of putting it, unfair? That probably would be more of a case-by-case kind of thing rather than, but, you know, a lot of courts have looked at the reliability of the hearsay as being.
And I mean, that's sort of the next question, but not to get too far afield on that, but is why wouldn't we just treat the due process the same way we treat a regular confrontation clause problem? Because everything you're describing with regard to reliability is exactly what they used to do with regard to hearsay under the confrontation clause until you get to Crawford and.
Right. And if you do hold that the confrontation clause applies to the Sixth Amendment, then you need to look at what does subsection J in 42A 751 mean? Because it allows for the consideration of a report, which, you know, we've all been doing this a while. We know what that report looks like. It's going to have hearsay in it.
Yeah.
And that's,
Then it would run afoul of Melendez-Diaz.
I don't hear that anyone is trying to declare that statute unconstitutional because it violates the Sixth Amendment. So these proceedings are different. They're not administrative. We're not arguing that. They're not non-judicial. I'm not arguing that. They're judicial, they're criminal, they're adversarial, maybe even more adversarial than your typical probation hearing across the state. But they're not the type of hearing that would necessitate the application of the confrontation clause of the Sixth Amendment.
So counsel, you, at the beginning of your time, you said this is not a prosecution. So when does something stop being a prosecution and start being whatever it is we're saying it is?
In this context, when the defendant pleads guilty, Your Honor.
Okay.
The case law, and I haven't really briefed this that heavily, but when the defendant pleads guilty constitutionally, that issue's over.
So if a defendant, then this may be too far afield, but like if a defendant pled guilty to a jury, is it over at that point then?
Yes.
Even though there's a jury there?
Yes.
So at that point, theoretically, the state could introduce a whole bunch of hearsay, upon hearsay, the defendant objects, and it doesn't matter because he already pled guilty. Is that?
Theoretically, but I mean, I'd want to know the exact facts of that case.
Okay.
I mean, like if it's there's cases in which a defendant has pled guilty in a death penalty case. I am not arguing that a death penalty defendant doesn't have a Sixth Amendment right to confront his accusers, even though he's decided to plead guilty, to just allow to become a punishment case.
Okay.
And again, I'm not suggesting that this court decide the sentencing issue because.
Are there any limitations as to how much hearsay would be admissible in a deferred proceeding? Because the defendant potentially is exposed to a life sentence in some of those proceedings if it's a first-degree felony.
Well, limitation, I mean, obviously the rules of evidence still apply, Your Honor, so it can't be just any old hearsay, just, you know, oh, this guy told me that. No, it would have to be admissible under an exception or a non-hearsay rule like this was. But not any old hearsay is going to come in. And plus, if we start introducing a bunch of hearsay, and all under an exception, like we don't bring any witnesses, we just start passing out a bunch of documents to the judge, then that starts looking a little weird, and maybe that's a due process violation.
Is that the new test? Weird?
Yes. I should have briefed it.
This is weird.
Yeah, I should have briefed it, but I did not.
Yeah, I've heard you acknowledge that there is at least some confrontation right via the due process clause of the federal Constitution. And I've looked in your brief, and your brief has pointed out in some quotes that the defense counsel at trial, when he raised his objections, and he does say Sixth Amendment right to confrontation in a couple of those. But I'm just wondering whether in all of the different times when he raised confrontation objections, did he always characterize it in terms of a Sixth Amendment right to confrontation? Or is it possible that any of those objections were not restricted by his exact words to the court by Sixth Amendment such that it could be arguable that that argument was, if he said, for example, my confrontation right, could that be broad enough to be understood to reach a due process confrontation right?
Arguably, and if I don't want to misstate the record, but I looked at the record specifically for that purpose to make sure the council was always relying upon a Sixth Amendment confrontation clause idea and not anything else. Maybe, I don't know that all lawyers know about the Gagnon versus Scarpelli and Morrissey versus Brewer. I don't know that. But it was clear that they were relying upon what we now term Crawford.
Okay.
And even if they're less specific in some objections, though, and more specific in others, if they're consistent with saying Sixth Amendment, wouldn't we look at what the trial court would have reasonably understood the
Sure.
basis to be?
I think that's what we would be doing. I don't read the phrase due process or due course of law does not appear anywhere.
Okay.
In briefing and/or in the hearing itself. Certainly no citation to Morrissey or Gagnon. So my belief is the defense is always, and I don't fault them for that, this is their argument, but my belief the defense has always relied upon the confrontation clause.
Thank you.
So, I'm not arguing waiver here, but the defense counsel said an argument that a plea of guilty does not waive the confrontation clause right. That's incorrect. There are plenty of cases that talk about when a defendant pleads guilty, he waives a number of valuable rights, one of those being the right of confrontation. So we believe that to be, I'm not arguing waiver. That's not the basis of one. I'm arguing the nature of the hearing, confrontation clause doesn't apply. Unless the court has any other questions, the state urges the court to uphold the holding of the Court of Appeals and affirm that holding.
Thank you, counsel.
Just want to touch on a few points. First, I want to touch on this idea that a business record is somehow makes the confrontation clause not apply. 42A.751J is a very limited statute. It deals with the issue of restitution. It says a court can order a report to be made to determine the factors of a restitution in a hearing on motion to revoke for failure to pay restitution. And those factors are explicitly listed. It deals with earning capacity, employment status. It does not say that a court can rely on a case file entirely just to prove that a violation happened. It's limited to restitution, which is not the issue in this case. And I want to talk about the reliability, because the state did brief reliability at the last part of his brief. Reliability is a due process concern at this point. And to be clear, we're not arguing due process, because due process and confrontation clause are very different animals at this point. Under the due process clause, you don't have a right to exclude testimonial hearsay. You have that right under the confrontation clause. And the state cites in his brief a few, what he would call criminal proceedings or judicial proceedings in which the confrontation clause doesn't apply. I think he cites pretrial bail hearings, hearings on motions to suppress. I think it's important to note that in those hearings, under Texas Rules of Evidence 101, the rules of evidence don't apply to those hearings. And if you compare the Federal Rules of Evidence 1101 with Texas Rules of Evidence 101, there's a list of exceptions to which the Texas Rules of Evidence don't apply. The federal court lists revocation proceedings. The state, Texas does not list that exception. The Rules of Evidence apply. And in that regard, like an ex parte don't, it does make this a lot more like a criminal prosecution. And I also want to touch on where the line gets kind of drawn in criminal prosecution. It doesn't happen after a guilty plea, because sentencing is still part of a prosecution. The DA doesn't leave the room when a judge decides to sentence someone. And so I would just urge the court to recognize an ex parte don't. The court's already stated that the revocation process in Texas, outside of the burden of proof, it's similar to a criminal trial. I think the quote from the court is that it's a few procedural differences outside of the burden of proof. So the discussion about business records, reliability, all of that kind of is geared towards the rules of evidence and due process. The Confrontation Clause gives extra constitutional rights above the rules of evidence. And because the state of Texas has decided to apply the rules of evidence to revocation proceedings, the Confrontation Clause has to also apply because it's designed to address what the United States Supreme Court would call a shortcoming of the rules of evidence. And unless there's any questions, that's,
Thank you, counsel.
thank you.
The case is submitted. Before we call the next case, the court is going to take a 10-minute recess.
All right.